counsel and understanding. We, thine unworthy.
This Honourable Senate resumes its sittings for Friday, July 10th, 2020. Before the day's proceedings begin, take the opportunity to welcome back Senator Knight, who took some time off, however, continued to meet with us in our committees via Zoom, and never ever did he turn his camera on. So we were beginning to wonder if he was actually there. So welcome back, Senator Knight. Statements by ministers. Announcements.
Laid on the table of the Senate today are the following: General Consumption Tax Amendment of Rate Order 2020, the General Consumption Tax Amendment of Rate Order 2020 Resolution, the General Consumption Tax Amendment Regulations 2020, the General Consumption Tax Amendment Regulations 2020 Resolution, the Deposit Insurance Increase of Deposit Insurance Coverage Order 2020, Annual Report and Audited Financial Statements of the Registrar General's Department for the year 2018-2019, Government of Jamaica Financial Statement of the Consolidated Fund for the year ending March 31, 2020, from the Accountant General's Department. The Integrity Commission Special Report of Investigation, Petrojam Report Number 1, conducted into allegations of acts of irregularity and/or impropriety, conflict of interest, corruption, nepotism, cronyism, and favoritism at Jamaica, Petrojam Jamaica Limited. The Integrity Commission Special Report and Investigation, Petrojam Report Number 2, conducted into allegations concerning certain donations which were made by Petrojam Limited to organizations and causes for the period April 2016 to March 2018. Corrigendum, Special Report of Investigation Report Number 2, conducted into allegations concerning certain donations which were made by Petrojam Limited to organizations and causes for the period April 2016 to March 2018. The Integrity Commission Annual Report for the years 2019-20, which ended March 30, 2020. The Public Bodies Management and Accountability Nomination, Selection and Appointment to Boards Regulations 2020. Public Bodies Management and Accountability Nomination, Selection and Appointment to Boards Regulations Number 2020 Resolution under the Public Bodies Management and Accountability Act. Report of the Senate Regulations Committee on its deliberations on the National Housing Trust Housing Benefits Ruthven Towers Housing Development Order 2020. Report of the Senate Regulations Committee on its deliberations on the National Housing Trust Housing Benefits Special Selection Darlington Grove Housing Development Order 2019. Report of the Senate Regulations Committee on its deliberations on the National Housing Trust Housing Benefits Silver Sun Housing Development Order 2020. Report of the Senate Regulations Committee on its deliberations on the National Housing Trust Housing Benefits Special Selection Fort Hill Estates Helshaw Phase 3 Housing Development Order 2019.
Thank you, Madam Clerk. Bills brought from the Honourable House of Representatives.
The following is a message from the Speaker of the House of Representatives to the Honourable Senate. I have the honour to advise the Honourable Senate that on the 7th day of July 2020, a bill entitled An Act to Amend the Special Economic Zones Act was passed in the House of Representatives.
Mr. President, I signify my willingness to take charge of the bill.
Right. A bill shortly entitled the Special Economic Zones Amendment Act 2020. Right.
Mr. President, I beg to give notice of second reading of the bill.
Petitions, papers, reports from committees.
I beg to lay on the table of the Senate the following 4 reports. 1, the report of the Senate Regulations Committee on its deliberations on the National Housing Trust Housing Benefits Ruth Van Towers Housing Development Order 2020. 2, the report of the Senate Regulations Committee on its deliberations on the National Housing Trust Housing Benefits Silver Sun Housing Development Order 2020. 3, the report of the Senate Regulations Committee on its deliberations on the National Housing Trust Housing Benefits Special Selection 4th Hill Estates Hellshire Phase 3 Housing Development Order 2019. And 4, the report of the Senate Regulations Committee on its deliberations on the National Housing Trust Housing Benefits Special Selections Darleston Grove Housing Development Order 2019.
Thank you, Senator Brown. Notices of motions given orally.
Mr. President, that's quicker than I expected, anyhow. Mr. President, I beg to give notice that at the next meeting of the Senate, I will move the following motions. 1, be it resolved that the report of the Regulations Committee of the Senate on its deliberations on the National Housing Trust Housing Benefits Ruth Van Towers Housing Development Order 2020, which was laid on the table of the Senate on the 10th day of July 2020, be adopted. 2, be it resolved that the report of the Regulations Committee of the Senate on its deliberations on the National Housing Trust Housing Benefits Silver Sun Housing Development Order 2020, which was laid on the table of the Senate on the 10th day of July 2020, be adopted. Be it resolved, be it resolved that the report of the Regulations Committee of the Senate on its deliberations on the National Housing Trust Housing Benefits Special Selection 4th Hill Estates Hellshire Phase 3 Housing Development Order 2019, which was laid on the table of the Senate on the 10th of July 2020, be adopted. 4, be it resolved that the report of the Regulations Committee of the Senate on its deliberations on the National Housing Trust Housing Benefits Special Resolution Darleston Grove Housing Development Order 2019, which was laid on the table of the Senate on the 10th day of July 2020, be adopted. And Mr. President, I also beg to give notice that at the next meeting of the Senate, I will move the following motion. Be it resolved that the deposit insurance, increase of deposit insurance coverage order 2020 under the Deposit Insurance Act, which was laid on the table of the Senate on the 10th day of July 2020, be referred to the Regulations Committee of the Senate for consideration and report. Mr. President, I further beg to give notice that at a later stage today, I will move for the suspension of the standing orders to enable me to make this motion. And Mr. President, I will only say that this is actually a little harder than I thought. It's not as easy as it looks.
Thank you, Senator Brown. Questions and answers to questions? Motions that may be made at the commencement of public business requiring notice. Motions relating to the sitting of the Senate.
Me.
Motions for leave to introduce bills. The presentation of bills without the leave of the Senate first obtained. Public business. Minister?
No, the entire. Use this one work.
Thank you, Mr. President. Mr. President, it is intended today to seek the approval of the report of the Joint Select Committee. Of the Joint Select Committee appointed to complete the review of the Sexual Offences Act, along with the Offences Against the Person Act, the Domestic Violence Act, and the Child Care and Protection Act. And it is also intended to take the motions, notice of which was just provided by Senator Braham. It is intended to proceed with them in that order. Mr. President, whether you are a victim, a victim's family member or friend, a witness or someone living in fear, Mr. President, violence destroys. The impact on our communities and our children in particular cannot be understated. Emotional disturbance, antisocial behaviors, substance abuse, reduced ability to concentrate and learn, these are all symptoms which in many cases can be traced back to violence in homes and communities. High levels of stress and desensitization helps perpetuate the cycle of violence as well, as between adults and children and as between those groups. And they contribute, Mr. President, to the levels of abuse experienced and reported. Mr. President, this motion does not propose to examine the phenomenon of violence generally. It is focused on a subset of violent crime, and in so doing, I do not seek to undervalue any aspect of violence in our society. Young and old, man and woman, boy and girl, every Jamaican life is precious. But I believe, Mr. President, that increased barbarity to which our women and children are subjected requires focus. The increased depravity and indifference to the lives of women and children, that was what moved me to move the motion. To my mind, too much has occurred for Parliament to take no action. Mr. President, this was how, in September 2013, I opened the debate on the private member's motion tabled earlier that year, which ultimately gave rise to the report before us for approval. Mr. President, at the time, the debate focused primarily on a few things. I called for a strengthening of penalties for offenses against 2013. Yes. I called for a strengthening of penalties for offenses against women, children, the elderly, and we added persons living with disabilities on the recommendation of Senator Morris. We called for the strengthening of penalties, in particular in relation to aggravated assault and the murder of pregnant women. Mr. President, I called for the creation of the criminal offense of stalking and harassment outside the context of besetting, which is the only offense which exists within the framework of the Domestic Violence Act, where a protection order exists for that particular type of behavior. And also different, of course, from the sexual harassment framework now being contemplated within Parliament, which is non-criminal and specifically within the context of employment or institutions. Mr. President, I call for the review and strengthening of the Domestic Violence Act in line with international conventions to which Jamaica is already signatory, and the inclusion of deported sex offenders on Jamaica's sex offenders registry. Thankfully, Mr. President, all of these recommendations found favor with the committee and are included in the report before us. Mr. President, as intended and as envisioned, the report goes far beyond these items, and its scope and complexity could be taken as partial explanation for the length of time that its completion took across administrations, but indeed only partially. But on a positive note, before I go through some of its elements, I wish to recognize that we have made some progress on complementary efforts. CISOCA has been given more resources, and police get better training on treating with domestic violence. Reports of rape are down, although we always have to be aware that reports must be examined differently from the existence of the phenomenon. Restorative justice programs are being rolled out to provide alternatives for communities in settling disputes. Mobile clinics have been established to increase community access to justice. The child diversion programs are being implemented, and 3 government shelters for women victims of abuse are being worked on. We've also secured funding under the Spotlight Initiative to support public education and related programs aimed at reducing gender-based violence and family violence. Although allocations have been a bit delayed by COVID-19, its programs are on our immediate horizons. So it's clear, therefore, Mr. President, that work to complement the legislative matters addressed in the report before us today have been underway. Recognizing the sheer scope of what is needed for the full transformation of our society to address this multifaceted issue of violence, the work and indeed the struggle continues. But today we take one more step in the Parliament's role in the work at hand, that is the making of laws for the peace and good governance of Jamaica. So members of this Honourable Senate will recall that in December 2016, a joint select committee comprising members appointed by the House of Representatives and the Senate was established to do 3 main things. Firstly, to review the Sexual Offences Act. Secondly, to consider and review existing legislation aimed at protecting women, children, persons living with disabilities, and the elderly from violence and abuse. Specifically, the committee was directed to place particular emphasis on the examination of offences committed against these groups under the Sexual Offences Act, the Offences Against the Persons Act, the Child Care and Protection Act, and the Domestic Violence Act. And also, Mr. President, it was to make recommendations for legislative amendment not restricted to the above-mentioned legislation for the better administration of justice and the effective protection of these groups as the committee deemed necessary. Pursuant to the motion I mentioned earlier, Mr. President, work to review the 4 above-mentioned acts began under a previous committee in 2015. That committee, however, did not complete its work prior to general elections held in 2016, resulting in the establishment of the last committee. Mr. President, the Joint Select Committee, the report of which we consider this morning, commenced its deliberations on January 18, 2017. It held a total of 19 meetings, with the last being held in December 2018. To assist with the deliberations, the committee heard submissions from approximately 33 entities and individuals representing civil society, international organizations, and other non-governmental organizations who are all advocates and partners in working for societal change on matters of violence, such as we have just mentioned. Additionally, submissions were made by the relevant ministries, departments, and agencies, including the Child Protection and Family Services Agency, the Office of the Children's Advocate, the Office of the Director of Public Prosecutions, the Bureau of Gender Affairs, Ministry of Health and Wellness, Ministry of Education, Youth and Information, and of course, SISOCA. Mr. President, the report of the committee was debated in the other place in late 2019 and is now before us. Mr. President, I'll take up front that the report is inconclusive on certain matters. Certain matters raised in submissions to the committee, such as buggery and abortion. Mr. President, it was advised that amendments to the relevant provisions under the Offences Against the Persons Act could give rise to other legal questions involving the interpretation of the Constitution and the protection offered by the Savings Law Clause. They were therefore recommended for wider contemplation by the Parliament. They are issues which are particularly contentious and on which public opinion is deeply divided. Had the committee perhaps focused on ensuring a clear position on those matters, we would be deprived of the benefit of the extensive and important improvements recommended, some of which I will now highlight, as we would have been still locked in debate. Mr. President, the first recommendation, which I will mention, is in relation to marital rape. Married women who are raped by their husbands will no longer have to fulfill certain conditions to qualify for legislative protection. The committee recommended that once a woman has withheld her consent in a relationship, irrespective of whether it occurs in marriage or not, it is to be considered rape. Among other things, Mr. President, it was recognized that rape is an act of violence, and marriage is an institution which must be fostered in a context of love and mutual respect, not violence. Mr. President, the committee recommended an increased penalty for grievous sexual assault in the parish courts, where, given that the penalty as it exists otherwise is already at 15 years and was deemed to not require increase. Mr. President, on the question of the age of consent, the majority of the members of the committee agreed to retain the age of consent at 16 years. There was deep and robust discussion on this issue, Mr. President, and in fact, I believe it may have been the only issue on which we felt compelled to call for a vote within the committee. And the majority view was that it would remain at that age, at that level. The committee has, however, on a related matter, decided to recommend the inclusion of a close in age provision of a 4-year ban, and this is again in the context of the Sexual Offences Act, Mr. President, which you know criminalizes sex under the age of 16. What was proposed is a 4-year ban to prevent children within a certain age range from being criminalized in circumstances where they willingly engage in sexual activity with each other. The fundamental point being, Mr. President, not to encourage this type of activity, but recognizing that its treatment by the justice system, the criminal justice system, is inappropriate and delivers poor results from all perspectives. Poor results in respect of the use of police resources, poor impacts on both young men and young women, and the unintended consequences of criminal records for activity which, even if ill-advised, is perhaps better treated as a social issue than a criminal one. Mr. President, the Senate is also reminded that under the new Child Diversion Act, where an offender is a child, the commission of such an offense, Mr. President, is now a diversion offense. And what this means is that the police or the court would choose to refer the offender to child diversion for therapeutic intervention rather than conviction and imprisonment. Mr. President, as alluded to earlier, the Sexual Offences Act has been recommended for amendment to place an obligation on persons who have relocated or been returned to Jamaica and have been convicted of a sexual offense abroad or have been listed in a sex offenders register abroad to report to the relevant authorities, and that as such they should be listed on the sex offenders registry in Jamaica. Mr. President, the committee also recognized significant weaknesses in the operation of the registry and therefore recommended expressly that the Ministry of National Security conduct a thorough review of the administration and operation of the registry. Mr. President, again also dealing with protection of our young people, a new offense was recommended for the creation rather of a new offense was recommended, and this is the offense of predatory sexual assault. And this is to penalize any adult who engages in sexual intercourse or anything amounting to grievous sexual assault with a vulnerable victim, defined as whether a child under the age of 12, someone with mental disorder. The description of vulnerable is dealt with elsewhere, Mr. President. Such a person would be guilty of an offense to be known as predatory sexual assault, and the recommended penalty for this offense would be a maximum sentence of life imprisonment. Mr. President, this provision was a result of a very, again, robust debate on the matter of rape and its definition and how much protection is given under our laws, and the perpetuation of what is referred to in some quarters as a rape culture, Mr. President, where use of benign terms such as sexual intercourse with a person under 16 so remove all of the impact and trauma that can occur around such an incident, where especially the relationship is one of trust and confidence. The committee was not minded to adopt the phrase used elsewhere, which is statutory rape, and there was in fact, there was ultimately an agreement that the creation of this offense, this language, would provide an issue, or rather a consensus around which persons could agree. Mr. President, in respect of the Child Care and Protection Act, Mr. President, there are now recommended under the report increased considerations for what is in the best interest of the child. And the committee accepted a recommendation to include provisions to ensure that continuity of education, for example, Mr. President, is considered when determining what is in the best interest of a child. Additionally, of course, Mr. President, a judge is empowered to include any other factors they deem necessary when determining what is the best interest of a child before the court. Mr. President, the recommendations also expand the duty to report that a child is in need of care and protection. And now in the schedule of persons who are expected to report, Mr. President, or rather who have a duty within the education sector, sports coaches were, for example, have been added. Mr. President, in respect of provision of care, a recommendation was made to provide an indemnity for service providers, for example, in the medical profession, who are duty-bound to provide services in the best interest of a child, but have encountered circumstances where they are required so to do, and there is either no parent around or no parental guidance around to grant such consent, to the prejudice of the child and to the anxiety of the medical professional or other professional where attention is needed. So it has been recommended, Mr. President, that an indemnity be granted, a statutory indemnity, again to ensure that persons below the age of 18 are able to access the type of care that they may need, notwithstanding the absence of parental authority. Mr. President, the committee has also expanded or recommended the expansion of the list of entities with a responsibility for receiving reports of child abuse, and this would now include, Mr. President, the JCF as well as the Children's Advocate, which are not provided for under the current CCPA. Mr. President, the matter of corporal punishment was also discussed extensively, And the position that has been recommended by the committee and was agreed to by the Ministry of Education, Youth and Information was that we were at a stage where we should move beyond the corporal punishment being prohibited only in early childhood institutions, which is the state of our current law, and that we should explicitly prohibit it in schools, public institutions for the care, instruction, or guidance of children who are in the care of the state. Also in public places was recommended by the committee. Mr. President, in the matter of detention and how it is that children interface with the justice system and the criminal justice system, the general mind of the committee was that the statute supports, or the system supports, the hardening and the ingraining of negative behaviors, and that there should be an attempt to find a better balance. And part of that would be the language used in legislation, so that where children come in conflict with the law, that instead of being detained in a place of safety, one of the recommendations, for example, is that they be accommodated in a place of safety. And just as a signal of the change of tone as to how children should be treated. On the matter of parental orders, Mr. President, the committee has recommended that in respect of the orders that courts may make in respect of treatment of children in need of care and protection, the committee recommended that courts be empowered to make what is called a parental order. And this is an order which imposes a stricter duty on the parents to ensure the good behavior of their children. And where they have failed to comply with the order, then such parents are required to attend parenting seminars and workshops, which will be prescribed and administered within the framework of government. As we know, we have the National Parenting Commission, we have the Child Protection and Family Services Agency, etc., which generally manage these matters. And of course, there's now child diversion committees, which provide another layer of social support and professional support. Again, the intention being not to always resort to a criminal justice action, but to see what can be done in creating a more balanced and a less aggressive and violent society. Mr. President, even in matter of transporting children to court, children in need of care and protection, one of the committee's recommendations was that they should not be brought by a constable. These are not necessarily children who have engaged in criminal offenses per se. They may be defined like that, but the nature of the offense is not necessarily criminal. These may be children who have been brought by their parents as being beyond control, but that it may be a difficulty to manage, an inability to manage, and not necessarily the criminal conduct of the child. And even there, so the committee has proposed that the law be amended to actually mandate responsibility to the CPFSA to see to the transportation of children from where they are in places of safety, rather than to have them be hauled by a police, trained to engage differently. So that is another one of the recommendations which were made, important recommendations made. Mr. President, on the matter of the power of a parent to bring a child before the court for reasons of that child being deemed beyond control, and we've heard the discussions generally in the public domain of uncontrollable children. The clause uses the words beyond control. The committee did consider the matter of this provision and recommended that the term be replaced with more appropriate terminology that acknowledges that maladaptive and other behavioral issues in children are usually a manifestation of other issues and not necessarily criminal intent, Mr. President. So this revision would then assist the court with more comprehensive consideration on whether correctional orders are in fact appropriate in the particular circumstances. But the issue continues to be reviewed by the relevant ministries based on recommendations which have been made by Jamaicans for Justice. However, it is to be noted that the Child Diversion Act was not in place when the committee sat. It hadn't yet been completed and it wasn't yet taken before this Parliament. So we're now significantly ahead of the game in respect of how of an alternative framework for dealing with children who come in conflict with the law. And this gives the court far more options in terms of how they deal with children, and it allows for a framework. You may have seen, senators may have heard the Minister of Justice speaking about Cabinet's approval of 13 child diversion committees appointed across the island, the creation not only of justice centers which allow for communities to have additional places within which to engage separately, but the child diversion committees have persons who are qualified in the different sectors which would ensure appropriate consideration is made for the health, well-being, and care, and where necessary, rehabilitation or recommendation for treatment of children, because it may require from drug rehabilitation treatment to other therapeutic endeavors. It may be mentorship. It may simply be taking greater guidance guidance counseling. But it is about providing a fundamental shift from ensuring that our young people, when they have behavioral issues, that the only alternative for a parent who cannot clearly afford to hire private psychologists is to engage with the court. So there's a new framework now, and therefore it will be, the recommendations even of JFJ will be considered in that regard. And it is hoped that over time we will no longer hear about this being used or necessary, and perhaps the amendment will be made. Mr. President, in respect of detention of children, it has also been recommended that the police should also notify the children's advocate where a child has been detained. And it has also been recommended that the Offences Against a Person, the Child Care and Protection Act be amended expressly to ensure that detention of children in adult correctional centers is prescribed. So it must now be prohibited, Mr. President, in law, even if it is already a matter of policy. Mr. President, there's also the recommendation, somewhat more broadly, of the development of foster care regulations to establish standards and protocols for children in foster care, reporting mechanisms for breaches for those standards, legal rights of foster parents and children relative to the rights of biological parents, and a foster parent registration system, again to support the alternatives to state care, always where there is not a stable situation at home. An alternative family arrangement, which is properly supported and regulated by the institutions of the state, would definitely be preferable, as a family environment is always a better choice for caring for a child. Mr. President, in respect of the Offences Against the Persons Act, common assaults have been recommended for a strengthening of penalties, and in particular, the committee recommended that the law be amended to make assaulting vulnerable persons, so no longer only women and males under 14, as it's under Section 40 of the OAPA, but persons with intellectual disabilities, persons over 70, and children. So the law is to be amended to expand protection to all those persons, so that it will be an aggravated offense, liable for an increased penalty where they are aggressed. Mr. President, the committee has recommended that willful or reckless transmission of STDs also be a criminal offense. And although I know that UNAIDS has issues with that position, this is a recommendation of the committee. And again, in respect of stalking, the committee recommended that the substantive criminal offense of stalking be included either in the Offences Against the Persons Act or the Sexual Offences Act, and that it be created here. And this was also recognized to have been a recommendation of the constabulary force when they were making their recommendations, not only to this committee, but to the Cybercrimes Committee, because their position had been that the better approach to the law would not be to create an offense of cyberstalking. It would be to create an offense of stalking and then allow the Cybercrimes Act to make it an offense which can be committed by use of a computer or other digital device. Mr. President, the final act put before the committee was a Domestic Violence Act. Mr. President, the committee recognized that the current legislation does not even define domestic violence, nor does it make it a crime. Mr. President, it was recognized by the committee that in light of the increase in domestic violence cases, greater protection must be provided under the Act, and as such, they agreed that a definition must be formulated and that it should be guided by international conventions. It should recognize physical, sexual, emotional, and psychological aspects of violence. And Mr. President, the data has shown that the lifetime prevalence of intimate partner violence by Jamaica was at a rate of 27.8%, Mr. President. That is a significant number of women to have experienced violence by an intimate partner. Mr. President, the committee was also of the view that there should be an expansion of the persons or entities who can make protection orders. It was determined, Mr. President, and recommended that the Children's Advocate, and by exercise of residual ministerial power, the Bureau of Gender Affairs should be included as entities with power to seek protection orders on behalf of a victim. The point being, Mr. President, that where victims feel comfortable to approach an entity, where they may not feel comfortable to engage with the constabulary, that there should be a way in which a protection order may otherwise be sought for persons who are in this particularly vulnerable and fearful situation. Mr. President, there has also been a proposal for an increase in penalty for breach of a protection order, and it is to be moved from $10,000, if you can believe it, or 6 months imprisonment, to $150,000 or 12 months imprisonment. But it has since been recommended in that other place, Mr. President, by the minister responsible for this act, that the monetary penalty would be moved to $500,000 instead. Mr. President, notwithstanding the material recommendations for amendments made by the committee, it was also recommended that more is required to send a signal that we are serious about protecting victims of domestic violence and abuse. So there was a general recommendation made for amendments that the law should be sufficiently impactful to ensure that anticipated violence can also be prevented. So we look forward to seeing exactly what is proposed in light of that amendment, Mr. President. And it is for the reason of the importance of this legislation, Mr. President, which is long overdue review and amendment, that the Minister with responsibility for gender has already indicated that she is taking steps to seek Cabinet approval for the enactment of modern legislation which comprehensively addresses the prevalence of domestic violence in our society in accordance with the suggestions that have been made to the committee. In respect of general recommendations, Mr. President, my final point is that aggravating factors and an increased penalty in relation to aggravating factors were also addressed, so that acts of violence, I referred to this earlier, but more specifically now, including sexual violence perpetrated against our most vulnerable groups in the society, and I repeat, children under 12 years old, women, or rather elderly persons over 70, women known to be pregnant or who are visibly pregnant, persons with physical or mental disabilities, that they should all be treated as aggravating factors in determining the sentence of an accused person, and that these aggravating factors should carry a mandatory minimum of no less than 20 years. Mr. President, I want to express gratitude to all members of the public who made written submissions, who took the time to do their research and to make submissions to the committee, to the staff of the various government entities who worked tirelessly, Mr. President, in providing support, and to the members of the committee for their efforts, the technical work that was necessary on these 4 very very important bills with definitely not only emotional but deep issues where deep-seated personal beliefs are also held in addition to the technical work. It was all extremely challenging, and therefore the work that was done was significant. I want to assure Mr. President that this report is not just another review exercise. I believe we can all agree that it is a significant step towards ensuring the safety and protection of the most vulnerable in our society. I therefore look forward to members' contributions today and to their ultimate approval of the report, which will pave the way for the completion of the requisite legislative amendments. I thank you, Mr. President.
Thank you, Minister, for that comprehensive overview.
Mr. President.
Senator Fraser-Binns.
Thank you, sir. Mr. President, I rise to make brief contribution to this report, the report of the Joint Select Committee appointed to complete the review of the Sexual Offences Act along with the Offences Against the Persons Act, the Domestic Violence Act, and the Child Care and Protection Act. Mr. President, let me say that this process has been a very long and involved process. And like the Minister, I too want to express my gratitude to the members of the committee. It did start in the last administration and it continued. As Minister said, this motion really came about from our own conviction of some thoughts and some feelings and what was happening at the time. But what was interesting is that in the committee, we had over 20 different groups that participated, individuals who participated, and they were able to share their views on these matters. At times, it got very emotional, but I believe at the end of the day, we can all agree that it was time well spent. And I really want to thank the staff for the time and the dedication, but I also must thank the staff specifically at the Ministry of Justice, because you see, Mr. President, there was a time when we just did not have the space here, and the Ministry of Justice housed us, and in quite fine style. And I don't think we were left wanting in any way at all. And so I want to express our gratitude to the staff at the Ministry of Justice. Mr. President, this, and the Minister has done a good job of giving an overview of this report, but there are just some areas that I want to highlight. And the first thing that I want to highlight, because it means so much to me, is the focus of this bill, well, the recommendation to deal with vulnerable people, persons with disability, and the fact that there is no provided, and in keeping with the Disabilities Act, there is no provided, or the intent is that there will now be provided expressly in legislation provisions to deal with the most vulnerable. And I think that is in fact a commendable and a positive step, and something that we on this side support fully. The other thing is that the bill, the proposal from the committee at page 25 speaks to the provision of parenting education. And that is something that finds favor with me. Because you see, Mr. President, what I find is that oftentimes, in my former life, when I had to go to the family court, you find a parent comes for abuse or for something. And when you talk to them, it really comes out of a place of frustration. We recall, I think it was last year, there was a situation in St. Thomas that got a lot of airplay. And when you delve into it, it really, the abuse that was meted out to the child by the parent really came out of a place of frustration, of the parent wanting what was best for the child, but was just totally unable to articulate or to express that desire. And so she reverted to what she knows, which is to give some licks to the child, and that really went beyond what she intended. And my understanding of that situation is that she was enrolled in counseling sessions. She now has an appreciation of what happened. And not only that, but she is far better prepared to handle the challenges of parenthood. Because as a parent, I can tell you, Mr. President, it's not easy. And, you know, in the best of times, you can lose your patience. And sometimes, you can ask Dr. Longmore, Senator Longmore, she will tell you, you do lose your patience. And it has nothing to do with your love for your child, you know. And when your 4-year-old don't want to go to bed at 10 o'clock in the night and you want to sleep, you know. And Matthew, you understand that. Yeah, but seriously though, Mr. President, the point I'm making is that in the best of situations, it happens, you know, you lose your cool. And it has nothing to do with your love for your child. And so I am very happy that we are saying that parenting education must be something that we consider in our courts. And there's precedent for that. Because when you go to the drug court, one of the things they do is you go through a drug counseling session. And it is not perfect, but there are a lot of benefits. Persons understand, persons are made to know how to deal with their emotions. And so we have seen it happen in the past. And I believe that now putting that focus on parenting so parents understand is important. Senator Longmore, I remember having a conversation with Prof. Samsvon about this whole situation. And I said to her, you know, one of the things that I would love to see is that the moment a mother goes to the clinic for prenatal care, that the spouse goes along with her and both of them are enrolled in parenting. So you start from the moment of use the antenatal clinic, exactly, as part of parenting, as part of the parenting education. And that is something that I know Senator Gale supports. Senator Gale, I know it is something you support. And I am very pleased, Mr. President, that we are heading in that direction. Mr. President, one of the issues that we looked at was the issue of begging under the Child Care and Protection Act. And the Child Care and Protection Act now speaks to the fact that children ought not to beg. And, you know, I was very happy. What page? Just scribbling down there. Oh, I'll tell you in a minute what page it is. I can't remember. But I was very happy when we spent some time discussing that in the committee. Because, you know, when I was at the Office of the Children's Advocate, one of the things that we discussed a lot, and it consumed a bit of our time, was how do we treat with begging, you know? Because it is a reality. And how do we treat particularly with our children who go on the street with our teens representing some, whether it's a school or some entity having a walkathon? Is that deemed begging? And if it does deem begging, are you then in conflict with the law? So I am very happy that what we have done is that we have sought to make a specific provision for those instances where, whether it's your school or your clubs or your society, they're having a walkathon. So you can feel free to know to go out and seek donation. And that is separate and apart from what we call begging. So I'm very happy for that clarity. But the issue of begging is something that I believe that we really have to give some thought, we have to give some serious focus to. You know, a couple of years ago, driving along Waterloo Road, and my mom would tell us about it. There was a little boy, and he was begging. And she said, so where's your mommy? she's at home. This is like 11 o'clock in the day. She's at home. It's like, what's she doing at home? Oh, she's at home sleeping. Why is she sleeping? Oh, she got dance last night. And that's the reality. So my mom is like, so does she know you're here? Yes, she sent me here. And that is the reality we have. So the parents send the child out to beg. The money comes in, and that money is used for sometimes to maintain the child, sometimes for other things. And so it is important that we start, as a result of that, I should tell you that it pains my heart, but when I see children on the street begging, I don't give it to them because they're encouraging them. And I think as a society, no, I don't. I do. I send them home. So I think it is something that I'm very happy we have spent some time on that. The issue of adult detention, Mr. President, the UN Convention does speak to the fact that children who are in trouble with the law ought not to be housed in the same space as adults. I recall again from my experience back in the days that there are many a times when we have had to enter under reference because we would have received reports that children are being housed in adult correctional center. And I do know that an ongoing policy of successive governments that this must not be. And there have been efforts to create space so that children are not housed with adults. But I am pleased that it is now being stated expressly that in the law that children who are in conflict with the law must not be housed in the same place with adults, and that find favors. Mr. President, one of the things that, and I think once I spoke about the whole issue of land, and I mentioned it, when we spoke about the issue of crime and looking at the various pieces of legislation, we discussed it, that the challenge we have is that there are so many pieces of legislation and different aspects dealing with so many different things. What we lack is uniformity. I am very, very happy that there is at least an attempt to create some kind of uniformity. So what you see happening is that the provisions in the Offences Against the Persons Act that deal with children it is now being proposed that those provisions will be taken out and put in the legislation dealing with children, which is the Child Care and Protection Act. I think it is a commendable move. I think it will make it easier for persons to read, easier for access, and I'm hoping that in drafting, the words will be simple, easy, so that everybody can understand. And that, Mr. President, is something that must be commended. Mr. President, the issue of the rights of children in the care of the state, and I think it's important, again, you will forgive me for making these references to my experience, but I spent a number of my years working in the children's services, so I do have some experience. And one of the things that we had done was a survey in the places of safety and the children's home to ascertain the extent to which these children were aware of their rights under the UN Convention. And interestingly, a significant number of them were not aware of it. Some of them were. But what was also more interesting is that there was not a general, and that was some time ago, so things I'm sure would have improved then, but there was not a general knowledge of their rights by these children. And, the Office of the Children's Advocate, and I have to commend them, have literally undertaken to ensure that children are made aware of their rights and responsibilities, but their rights as contained in the United Nations Convention on the Rights of the Child. And so issues such as your right to an education, your right to play, because that is a right. Every child has a right to play, and there's a reason for that. Senator Longmore will support that view. There's a right to education, a right to play, a right to be free from non-discrimination, a right to life, survival. And importantly, though they may be in the place of safety, they have a right for their views to be respected. And I am very happy that we have reached a point in our development and maturity that we are accepting that children have these rights, and children in places of safety and children's home, well, more places of safety, have these rights, and we must recognize them. But I want to put in a quick plug, Mr. President, because we often talk about the rights of the child and the rights and the rights and the rights, but equally, we must emphasize the responsibilities, because rights and responsibilities go hand in hand. And while we promote these rights, I also want us to promote the responsibilities that these children, though they are minors, that they have. Mr. President, the fact is that the focus or the debate on this report is timely and comes at a most opportune time, because it looks at issues affecting our children, our women, and our boys. But, you know, I do recall about a month or two ago reading one of the nation's paper, and it spoke to an increase in the number of sex crimes against our children. And, you know, it pained my heart. It pained my heart because this, for a lot of children, this is perhaps the most vulnerable time that they'll experience, and a time when they require love and attention and care. But it is a time when the number of cases and instances of abuse is on the rise. And, you know, for example, the figures show that of the 700 victims in the month of March, 368 of those victims were children, and 379 of the victims in April were children. That's more than half of the number of new victims. I mean, any new victim is one too much, but to consider that more than half of these new victims are children, it pains our heart, and particularly at a time like this. And, you know, the figures, and this was a report from the Victim Services Division in the ministry, the figures show that children under 11 years old accounted for 45 of the sexual cases, and between 12 years and 17 years old, 114, and 186 for people over the age of 18. And 88 of all these victims were males. So there are two things coming out. One is that there is clearly an increase in the number of sexual abuse among our children, but that our boys are also falling victim more and more. And I want to talk a little bit about the boys, because the truth is that we have spent a lot of time focusing on protecting our girls, and with reason. But what we now need to do is to focus on protecting our children, boys and girls, because increasingly our boys are being left behind. Increasingly, and it is perhaps it's a society in which we live, where we do not believe. You know, I do recall a report of a male who was molested, he was assaulted, and when he went to share it with some persons, they laughed at him and said, "So, you have a problem with that?" And he said, "I do, because I did not want it." And they could not understand how come a man would not want a sexual advance. He's like, "I didn't choose it for myself." And he was heartbroken that the persons to whom he reported this situation and sought their assistance, some of whom were his friends, could not understand the pain he felt by being sexually abused. Because it's a man. I mean, why would you have a problem with it? And that is the cultural reality we face. But the fact is that in 2020, we can't continue with that kind of reality. We now have to stop and say, how do we protect our boys equally as we protect our girls? And so I am very happy that the language, the recommended language in these pieces of legislation will be gender neutral, because it shows an acceptance and a recognition that boys and girls, males and females, need equal protection. And I'm very happy about that, Minister. And as I wind up, Mr. President, I just want to say three things. One is that I fully support the recommendations from the committee. Of course, I was a member of the committee, so I do support the recommendations. But what we do not lack in Jamaica are laws. What we lack are enforcement, just the plain, simple will to do things. And I am sure, Minister, that was one of the things to which you addressed your mind when you tabled that, that motion a couple of years ago. So what is required is we enforce. We have to enforce, we have to enforce, we have to, I can't say it enough, enforce, enforce, enforce. Enforcement is going to be critical to give life and effect to this bill. Enforcement is critical if we are supposed to save our boys and girls, or males and our females. The other thing as well is public education. You see, and Minister, you spoke about incest. And I didn't, because I believe you covered it. But one of the things that, and I don't think it's unique to the country, but I'm a country girl, so I can talk about it. But I don't think it's a country thing. I think maybe it's a Jamaican thing. We have these cultural myths that you do certain things for certain things. So, for example, there's a feeling among some of us that if you, for example, have sexual intercourse with a virgin, that if you have a disease, a STD, it will be cured. It is a cultural myth. Another cultural myth is that passing Christian in Pitney first. And so there are, looking at the issue of incest, there are some amongst us who believe that it's their daughter, they send them to school, they maintain them, they provide for them, so they must have the first pick of it. And it is our reality. To that extent, public education is going to be important. So you have the enforcement, but we need the public education to change the mindset of our people so they understand it don't work like that. And that the long hand of the law is going to catch up with you, and we're going to deal with you. There's a sure certainty of conviction. And finally, Mr. President, while I commend and I fully support this, I want to plug in something, Minister, for your consideration and for where you sit at another place, the Adoption Act. I put a motion, I moved a motion a couple of years ago about it. It's something that is personal to me. I mean, it is so personal to me, you can't understand. And I am putting in a plug for us to really move. I know when former minister in charge of youth, Green, was there, that things were happening. I did have a conversation with President Minister, but I believe that we have to move with alacrity. There are so many children just literally just in state care that you can't do nothing about. People want to adopt them, but you can't because the archaic law says you have to go through X, Y, and Z. And you can't do X, Y, and Z because of what obtains. I believe that time comes for us to move quickly, to amend the Adoption Act, to make it easy for persons who want to adopt, that they can adopt without having to cross over all those hurdles. And Minister, I'm asking you to just make that representation where you sit on a Monday for us to move quickly, and also for us to look at that motion that I had moved some time ago. With that being said, Minister, Mr. President,
before you close, which date you moved the motion?
2016. With that being said, Mr. President, I really want to just thank all the stakeholders again for their input and their work in reviewing this bill. I believe that the recommendations are solid recommendations. It will inure to the benefit of all Jamaicans, and I give it my full support. Thank you, Mr. President.
Thank you, Senator Fraser-Bin. Senator Longmore.
Thank you, Mr. President. I need the... seems so. It's a different incline. Thank you. Mr. President, I sat on the Joint Select Committee, and so we had much discourse that was very enlightening for me. It was my very first Joint Select Committee having been appointed to the Senate, and it was a very enlightening experience, and I'm very grateful to have been able to serve in this way. Thank you. As a mental health professional, I cannot underscore how very significant these pieces of legislations are in stemming some of the great issues that we have to deal with within our society. And it is not just a triumph for the legal and the justice aspect of governance, but more so the health impact, not just mental health. There's significant physical health that happens in abuse, and one of the underscoring issues for us is that the damage that is done is generational. It is not just the person that you see in front of you who is the victim. The perpetrators are usually victims themselves, and the abused tends to also perpetuate the behavior. So it is very, very critical for us to stem the cycle, and these legislations are a significant triumph in Jamaica's progress as a people in seeing to the needs of the most vulnerable within our society. Mr. President, we recognize abuse, the usual forms that we see as sexual, physical, and the emotional damage that is done. But I want to use this opportunity to also recognize something that it has become such a common occurrence that it's almost overlooked, even in professionals who are doing assessments, etc. And that is neglect, and especially paternal neglect in our society. The absence of fathers in our homes and in the lives of their children. And every opportunity I get, I will always underscore. In some homes, yes, no, we have some magnificent men and magnificent fathers in our society, and you can see the impact of their presence. But sadly, you also see the impact of their absence. And as a clinician, I tell you, I repeat the story that I mentioned here before of teaching medical students in how to assess a patient. And the significant majority of them, when they ask a question about family and the presence of the father, does not recognize that it is actually a form of abuse, that the father is neglecting the child and is not present in a child's life. So let us, I just want to make sure we underscore and don't lose sight of something that is so impacting in our society at this point in time. And I'm grateful again for these legislations that are bringing this to the fore. Just a few, as I said, I sat on the Joint Select Committee, and there were many issues that we debated back and forth, but just a few to underscore here that I think are great strides in moving forward. The statutory indemnity for persons to seek care in the absence of paternal authority, I think is quite significant for us, and especially as a medical professional and persons and places of first contact with victims, it is very critical for us to know that there are avenues for recourse and for actually seeing to the victim in the moment. And so I celebrate that particularly. Senator Fraser Binns, well, she's now stepped out of chambers. But your call for the increased education around parenting and such is one that I have made myself in my past State of the Nation presentations, in terms of using the antenatal clinic time. And many times women go in and they register at this antenatal clinic. They go there every so often for their checkups. And they sit for hours on end waiting for their appointment. It's a valuable time to be imparting audiovisual information about parenting and incorporating the fathers in this very critical process. Another point that was brought in terms of legislation seeing to children not being housed as would be with adults in terms of offenses, and providing special facilities for child offenders, etc., etc. It relates to us in psychiatric care, where you have, and it is a grave issue that we have, that we're hoping there will be some resolution, but in like manner, it is a great issue where children with mental health don't have a specific treatment facility where they, when admitted, they currently have to be admitted along with adults. We need, presently at University Hospital. Bellevue does not admit children. No. Right. Yes. And there is, pardon? Yes. They are housed on the same ward as with adults, because we just don't have that level of facility available. There are plans afoot, but I implore my advocacy for that to be challenged, just as we have seen legislation laid here now to see to offenders being separated. The uncontrollable children, I implore, and the revision and the recognition that these uncontrollable children usually have underlying issues that needs to be addressed. I especially celebrate, but I also want to bring it to the attention of the professionals who are making the assessment of uncontrollable children. And let me just give a little background here. The clinical diagnosis is usually made is a conduct disorder. When you have a child who is unruly, who is breaking laws, who is committing offenses, etc., 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 and below the age of 18, conduct disorder. When you write a report that indicates conduct disorder as your primary diagnosis, you immediately project a particular picture, image, to the person who is receiving that report. Invariably, almost all of these children have underlying abuse history, have underlying neglect issues. It is my personal thing where I put that as my primary diagnosis. And I implore professionals who are making these recommendations that you also highlight that this person is actually a victim of abuse with secondary manifestations of conduct disorder of a behavioral nature. It makes a significant difference to the person who is receiving that report that they immediately treat the child in a different way, where it is victim of abuse with secondary conduct disorder issues versus conduct disorder and no mention of the abuse. So a significant recommendation to the professionals involved. I also appreciate the fact that we're getting also more, the definitions around mental disorder and intellectual disabilities are more in keeping with what is currently the standard in the DSM-5, which is the manual for definitions of such mental issues and such. So I'm very glad to see that we're progressing with what is best descriptive of the conditions that exist. My final, as I said, I was part of the Joint Select Committee, so I don't have to thrash through a lot of issues here. But my contention, as other members may recall, was, for me, the age of consent. And I still hold, it is reflected, as the Minister mentioned, it is reflected that the majority in the committee sought to see it remain at 16. But a very strong minority, of which I am one, still champions for the age of consent to be increased to 18 years old. And my rationale, Mr. President, is based on the fact that a child is 18 years and under. The definition that we work with, that a child is 18 years and under. A 17-year-old who is abused, in my mind, is still a child. Even though consent may have somewhat been given, they're still a child. It makes no sense in my mind that our voting age is 18, alcohol consumption is 18, a driver's license is 18. Why are we having, 17, same, okay. Why are we having a situation where the 16 to 18-year-old who is considered and recognized as a child is being allowed to probably create a family that they cannot support? It is incongruent, and what throughout the legislation, and I remember, may his soul rest in peace, Dr. Linval Bloomfield was also fervently in support of the age of consent being raised, because as practitioners we see it. We know that there are circumstances in communities where we hear the horrific projections of area, bad man, watching young girls grow, mature, and is literally knocking on the door and say, hey, she's so reach 16, you know. Yeah? Because they know that they are legally protected. In terms of, okay, once the 16th birthday gone, the consent can be given. So it is a real issue for me, and I hope that it is something that we are able to revisit. It makes no sense to me that we recognize children as 18 and under, but we are not recognizing the sexual assault that could happen to a 16-year-old, a 17-year-old, up until 18 years old, who is still a child in our society. I think we as a government, it is imperative. Justice is to serve and protect those, especially when they think they have no avenue and they have no other protection. As a government, we are, I think, obligated to enabling that every child is protected in such way. And with that, I end my minor contribution. Thank you.
Thank you, Senator Longmore. Senator Morris.
Thank you, Mr. President. I rise to make my contribution to the motion before us in terms of accepting the report from the Joint Select Committee. And I want to preface my comments, Mr. President, by making a few observations. One, the absolute importance of having a joint select committee to deliberate on complex issues to get consensus, stakeholder buy-in in the formulation of legislation. Very important, because whilst not all the issues that were up for deliberations were dealt with, it nonetheless, Mr. President, gave us some clarity on some of the issues that are before us today. And I'm very happy that this matter was brought to the Joint Select Committee. But equally important, Mr. President, is an advice to young members of the Senate of how beneficial it is to bring motions to the Parliament to debate. Because when you do that, you get the opportunity to formulate policies or put forward a motion that might impact on public policy. Once, as Senator Knight says, you get the motion debated. And I am very happy, Senator Knight, that I was the person sitting in the chair at the time when the motion was debated.
Actually, it was debated?
Yes. And I am very happy that the mover of the motion has moved on and followed through to ensure that the expressions that she brought to the Parliament at the time, that they were transmitted into public policy. And I commend you, Minister, where that is concerned. But I want to say as well, there are a number of motions that I have seen on the order paper that have been languishing. And we need to get these motions debated so that, we can ventilate the issues. It might not be issues that, we all agree. But I am certain that in this honorable chamber, we have displayed a level of maturity in terms of discussing the issues, and so we can debate those motions and get them approved. Mr. President, Minister in her presentation pointed out that I, whilst in the chair, made an intervention and appeal for persons with disabilities to be included in the motion, and it was accepted. And I am very pleased at the deliberations of the Joint Select Committee on the matter, because the committee did tremendous work. I realized that it's some 19 sessions that were held deliberating some of the issues, and matters relating to persons with disabilities were contemplated. My disappointment, Mr. President, Minister, is that when I went through the report, I only noticed one institution catering to persons with disabilities mentioned, and I don't know if other organizations with catering to persons with disabilities were invited or took up any offer to participate in the deliberation. But I noticed that there was just one institution, and the institution that was mentioned in the document was cited as the National Council for Persons with Disabilities. And Minister, just to point out for correction that there is no National Council for Persons with Disabilities. There is the Jamaica Council for Persons with Disabilities. Jamaica Council for Persons with Disabilities. So for the records, that should be corrected. Mr. President, I've just completed research at the university on violence against persons with disabilities and the justice system. And it is a very current topic for me and also in the academic space of which I'm a part. As a matter of fact, there will be a conference at the end of this month deliberating the whole issue of violence in the society, and this paper, research paper that I worked on will be featured in the conference. But Mr. President, just to point out that persons with disabilities are major victims of crime and violence in Jamaica, and this was confirmed in the focus group discussion that was held among persons with disabilities. And what we realize, Mr. President, is that these individuals, in experiencing the violence, have not been coming forward to report these violence because of the fear factor amongst this population. These are individuals who are very vulnerable, and because of their vulnerability, they believe that, rather than going to the police to take the matter through the justice system and expose themselves to further harm and danger, they rather suppress the acts of violence against them. And there has to be some form of mechanism put in place to give reassurance to these individuals that once violence is meted out against them, they will be protected. And I'm making an appeal to my very good friend, Minister Samuda, to ensure that, the security forces pay special attention in giving protection to these vulnerable individuals in their experience with crime and violence. Mr. President, one of the things that impact on the underreporting of violence against persons with disabilities is the inaccessibility of the justice system to these individuals. When you have a person with a physical disability going to the police station, most of them are inaccessible, so wheelchair users can't go inside the police station. A lot of the courthouses are not accessible to persons with physical disabilities. And here again, Mr. President, I think that they often say that the Parliament is the highest court of the land. And we have been having problems with access, and the mayor, in one of the debates in the Parliament, had committed to assisting with making sure that the entrance of the Parliament is accessible. And Mayor, I am reminding you of that commitment. Mr. President, you were party to that as well, because we want to see this building accessible until Senator Braham delivers the brand new Parliament, if he gets the opportunity to do so. Senator Lambert Brown, you're not hearing this one. All right? I just made an appeal to Senator Braham to expedite the construction of the new Parliament if he gets the opportunity to complete it. Mr. President, there is the absence of standardized services to persons with disabilities in the justice system, such as sign language interpretation. And all of this impact on the whole situation of violence and the access to the justice system for these individuals, which invariably contributes to underreporting of violence. And again, there needs to be that extension in the justice system as a standard whenever you have persons with disabilities involved with a particular case, that the requisite services are provided for these individuals. Mr. President, there is also the need for training of members of the justice system to relate to persons with disabilities. And there's a lot of sensitive issues relating to persons with disabilities. And I took note of the report, and I have to commend again members in terms of how they treated and handled some of the issues, because when it came on to the issue of dealing with individuals with intellectual disability, there was the argument for certain changes to be made for persons with intellectual disabilities to be categorized as children, and the committee indicated that this was very insensitive to refer to an adult with an intellectual disability as a child, notwithstanding the fact that an individual with an intellectual disability, in terms of their chronological age, some of them function at a developmental level as a child. So there's a distinction to be made between the chronological age and the developmental functioning of an individual with a disability, and the committee did take that into consideration. But what I'm saying, Minister, is that there needs to be, throughout the entire justice system, a training of individuals to understand how to relate and treat with the different types of disabilities. Because the different types of disabilities have their own peculiarities. And so you have to understand how to treat with them in the new dispensation. And again, I ask that, whether it be at the Norman Manley Law School, whether it be at the Center for Disability Studies at the University of the West Indies, or the Training Institute for Public Servants, that these individuals be brought up to speed as to how to relate with persons with disabilities. There is a need to modernize the language, and I am very happy that that is being dealt with, right? There is a need to modernize the language in terms of how we reference persons with disabilities. As I've said in previous debates in the Senate, that the correct and the acceptable international language is persons with disabilities. Once you use that reference, you are in unsafe ground. And even the Constitution, Mr. President, need to undergo some modernization in terms of its language, because if you read through the Constitution, you will see reference to lunatic and handicap and so forth. And there needs to be a modernization of the language in that context. And at some point in time, we will have to look at how we proceed in that context, because amendments to the Constitution requires a particular form and a particular treatment. Mr. President, I want to make it known that in giving special considerations to persons with disabilities, I've spoke to the whole situation of persons with intellectual disabilities, but I also want to speak to the whole situation of persons who are blind or visually impaired. Because, for example, Mr. President, oftentimes I have heard people make the statement that blind man can't go to court to testify because based on legal traditions, you require sight to give evidence. And this is a matter that has to be reviewed, has to be given particular treatment, because persons with visual impairment, persons who are blind, have a way of understanding and interpreting reality and their experience. And that has to be taken into consideration in a modern construct based on available research and literature that deals with the whole situation of violence and justice for vulnerable groups such as persons who are blind and visually impaired. Mr. President, intellectual disabilities has been included in the interpretation section of the legislation based on the recommendation of the report. And I welcome the inclusion. As I pointed out, there was some discussion in the Joint Select Committee about whether or not a person with an intellectual disability should be treated as a child, and the committee correctly went against that usage, but instead opted for including intellectual disability as a term in the definition section, and I appreciate the reference. I just want to make sure that all the disability groups are captured and covered in the legislation. And in that context, Minister, in your presentation, you spoke to physical and mental disorder being treated as aggravated offenses. I just want to point out, I don't understand why it is that those two disabilities, types of disabilities, Senator Braham, were specifically singled out. Because if you look at the Disabilities Act, you will see that the Disabilities Act refers to the different types of disabilities, which include physical, mental, intellectual, sensory. And sensory would cover individuals with speech impairment, persons who are blind or visually impaired, persons who have visual impairment or neurological disorders. So when I look at, and I heard the reference and I checked back the report, I saw it as well, the mention of physical disabilities and mental disorder. And if there is no specific and cogent reason for this, I am suggesting that we use throughout the document a standardized language of persons with disabilities, because this would pose some problems. This can pose some problems in the courts. I want to make an appeal to the society in general to protect the most vulnerable among us, our senior citizens, our children, persons with disabilities. These are individuals who we have to ensure that we do everything to protect them against crime and violence. These are individuals, by and large, who can't defend themselves, and we can't have individuals who are fully able preying upon and violating the rights and freedoms of these individuals. And I want to make a public appeal that we take back our society to those days, Senator Braham, when anything happened in a community with a senior citizen, the entire community is there to protect that individual. Likewise, a child. Everybody in the community in days of the past, absolutely, village raising the child, you know. So we have to make sure that we bring back our society to those days so that we give maximum protection to the most vulnerable in our society. Mr. President, I'm making an appeal to the Mayor of Kingston and all the mayors across the country to make sure that they keep the sidewalks clear of vendors. Because in the focus group discussion that I had with persons with disabilities, they complained that in walking in the towns and in the city, they have been subject to tremendous violence by vendors who, in walking on the sidewalk, use their white cane and they might just brush on their wares that they are peddling, and it causes serious problems between persons with disabilities and those vendors. And I am making that appeal, Mayor, because these persons with disabilities have a right to participate, have a right to go about their lawful business in the society just as anybody else. And we don't want this consistent mechanism where, you know, individuals are putting in all manner of impediments in their way. JPSCO has already done that with the light poles that they have put in the middle of the sidewalks and refused to move them from out of the way of the disabled. And we want to make sure that where we can prevent any further restrictions on these individuals, we do so. And say to the mayor, my friend, make sure that you assist me, just as how you supported me when I was at the university. I'm making a broader appeal for protection and support for the broader disabled community. And the final point that I want to make, Mr. President, is that there is a comprehensive set of amendments that will be put forward in terms of the new legislation, the amended legislation. And I want to suggest that when this is done, that, and I'm speaking specifically now to the community of persons with disabilities, that, you know, a sensitization program be embarked upon to sensitize these individuals of the changes to the legislation, and to encourage them that when violence is exacted against them, that they have a particular course of action to pursue, and that the state will give them full protection. Because if that public education and sensitization is not done, what we are going to continue to have is an underreporting of violence against these vulnerable individuals. And I want to make sure that as we move forward in a new dispensation and a new season where we are putting an assault on violence against vulnerable citizens within our society, we make sure that the information is not just contained on a bookshelf, but make sure that it is implanted in the minds of these citizens right across the country. May it please you, Mr. President.
Thank you very much, Senator Morris. Senator Sinclair.
Thank you, Mr. President. Yes, it's good. And I promise I won't be very long. Mr. President, when I got the sight of this report, went through it, it was very comprehensive, I must say. And so I start out by commending, first of all, President Leader of Government Business for having brought that private members motion in 2013. And all the members of the Joint Select Committee that, when you look at the report, would have deliberated long and hard, extensively, on the legislations that were placed before it. Mr. President, the Domestic Violence Act was one of them. And, you know, when in practice, you saw this $10,000 fine. I just thought it was ridiculous. $10,000. I mean, persons who just breach that and pay it. Nothing at all attached to it. And so the recommendation that is made in respect to even criminalizing aspects of the Domestic Violence Act is something that I do support. But, you know, in looking at the Domestic Violence Act as it is, and what was discussed and reported on in the Joint Select Committee, I still think that there's a little gap that needs to be closed. And I create a situation where the police is called to a house because someone within that household committed an act of violence. So the police turns up and sees evidence of that, whether it's a female or, because the Domestic Violence Act allows for occupation orders to be made even against persons who are children. Adult children may be in violence with the parent. But the police sees that. But then there's some emotion that is attached to the individuals that may say, I don't want to cause any prosecution. What does the police do in a situation like that? Do they just walk away from the scene and leave it at that because the person says, I'm not giving a statement? Because then the police has nothing really on what to act. But they see signs of violence. Now, in the United States, we have seen it when we watch Law and Order, and a little more than Law and Order. But there are documentaries that reflect it, and real life stories, though, where the police is able to remove the offending party from the home, even for a cooling off period. It is not something that I see referred to in the Domestic Violence Act. And I think there's a little gap in that, in the scenario that I would have created. So I would ask, as we move forward with the proposal to amend the legislation, that they be looked at. I see on page 39 an intention to amend the Offences Against Persons Act and to bring in the offense of stalking. Because, again, that is something that, as a practicing attorney, we come across women mostly. Not to say that I may not have been stalked at some point in time. But women generally you find come in and they indicate that they are being stalked. And you would have to try and work some gymnastics to try and find some way to prevent that from happening. Did the stalker come onto your property, or they coming onto your property? We try and use trespass in order to get some court action that may assist the process and to give them some peace of mind. And so I'm happy that this particular recommendation came out of the Joint Select Committee and should be moved on quickly. Mr. President, Senator Sapphire Longmore, in her presentation, she spoke about her desire of seeing the age of consent increased to 18. And good to see you back, Senator Knight. And I was able to hear the little dialogue that took place, where you sought to make a separation between the male and the female in respect to the consent. 16 for males, as I would have seen you making that comment, and 18 in relation to females. And it is something that, when I thought about it in the brief moment, it is something that is worthy of discussion. But in respect to the age of consent for females, I want to agree with Senator Sapphire Longmore. On her proposal, I stand with you on that, Senator.
Thank you.
And I would have to do that because in looking at the report, and although the objective of the report facilitated it, because when you look on page 3, in which it says one of the objectives to make recommendations for legislative amendment not restricted to the stated legislation under review, which have been identified, the 4 legislations that were identified, for the better administration of justice and the effective protection of these special groups as the committee deems necessary. When I looked at that, I said, well, apparently may not have been viewed as important, but it is something that has crossed my mind for some time, and it is the Marriage Act. The Marriage Act. Because our Marriage Act and other legislation, Mr. President, that deals with marriage, Muslim Marriage Act also, and the Hindu Marriage Act, allows for marriage of persons who are 16 years old with the consent of the parent. And it is something that has bothered me for quite some time. And I think it is something that we need to look at. It may not be something that you come across in Jamaica on a regular basis. In fact, I've never seen or heard of a particular case that I could refer you to. But the fact is that it exists within our legislation, allowing for a person who is a child under the Child Care and Protection Act. And with the implementation of the Child Care and Protection Act, which I think was 2005, and the Marriage Act, Hindu Marriage Act, Muslim Marriage Act, which existed before, I think we need to look on those 3 bits of legislation to make amendment and to move the age to 18. Because think about this, Mr. President. Think about this. In fact, before, as I said, all persons between 16 and 18 under the Child Care and Protection Act are defined as being children. There is in this inconsistency with the spirit and intent of the Child Care and Protection Act with what exists in those marriage legislations. And when you look at the Child Care and Protection Act, there are restrictions on children in employment, restriction on them entering into certain places and acquiring intoxicating liquor. But just say that a person got consent from a parent, got married to a person who more than likely would be over the age of majority, and that person decides to take his now wife to a club and to purchase intoxicating liquor. Something does not sit right in that situation with me. And so for us to have the consistency with the spirit and intent of the Child Care and Protection Act, I think there needs to be the amendment in the legislation to say that no one under the age of 18 can get married. Full stop. Mr. President, if we keep it as it is, then you may have scenarios where somebody, as we have been told by Senator Longmore, the Don who will just sit down and waiting and observing, or he may be doing a little more because the person says, well, I want to get married when I turn to 16, and the parents say, well, guess what? That man look like him is a man with little money. So what? You may be facilitating, unwittingly so, sexual grooming, which is a breach of the Sexual Offences Act, because the process would have started before the person got to 16. You just want the protection of the 16-year-old to get to 16-year-old, to have legal protection, but then you may have situations that you may be encouraging, unwittingly, as I said, sexual grooming of somebody who is under the age of 16. Other Caribbean countries have done it. They have made the amendment. Trinidad has done it. And so they have removed a situation where children between the age of 16 and 18 can get married. Their marriage laws says that you can only be married at the age of 16. The United Nations Committee on the Elimination of Discrimination Against Women have recommended to Jamaica the change of its marriage laws from 2012. I think it is time that we actually get on board. The Convention on Rights of the Child in 1991, they set their minimum age of marriage at 18. Again, since we seem to be consistent in respect to how these international bodies look on various legislation impacting upon the child, I think it is full time that Jamaica gets in line and to have the marriage acts that I made mention of, that they be amended to make the age 18 years and remove the possibility of consent. So, Mr. President, as I said, I will be short. Those were just some of the things that jumped out on me when I went through this report. As I said, it's very comprehensive, timely, and I think we must move with alacrity and to get the amendments to the legislation passed. If it so pleases you, Mr. President.
Thank you, Senator Sinclair. Senator Knight, I suppose your contribution is like getting back on a bicycle after you haven't ridden for a while.
Very difficult, and the thing that bothers me. No. He has left but not gone. it's going to take me some time to get back in. So rest and then return.
Welcome back, Senator Knight. Good to see
you.
you.
Thank you, sir. No, it's written. President, thank you for your words of welcome. And to the colleagues, when I came in this morning, I really was pleased. I felt missed. And it's a pleasure to be back. Whilst I was away from the chamber, but not from the proceedings, I watched something happening here. A new person came in. And so I heard various members congratulating the new senator. And they said some very nice things. And I joined in welcoming you. I happen to know very well one Courtney A.B. Hamilton, who I think you know too. And then I heard my colleague, Senator Fraser Binns, speak about an institution, Westwood High School. And I said to myself, my goodness me, because my aunt was the principal of Westwood for many, many moons. But there you go. And Member of Parliament Dalrymple, who I know well through my aunt, and who, was a great, I don't know though, how come the influence of my aunt fled from the institution, and those who ought to be here are there. President, I want to start out in this presentation by actually commending those who sat on the Joint Select Committee. It's one of the finest reports I've seen in the years that I have been in the Parliament. And let me tell you why I regard it as a fine report. It showed reflection on complex issues, and it sought to put forward ideas for change. I won't delve deeply into the report now because I anxiously await the results that ought to flow from the report. But I happen to know that it won't be soon. It won't be soon because it's going to take basically a comprehensive review of the interlocking statutes. And it is going to need a great deal of concentration by the Legal Reform Division, a lot of work for the Chief they are going to feel some strain in dealing with this. Because the issue, for example, that Senator Longmore raised about the age of consent cannot easily be dealt with, because there are two separate individuals, for example, who must be considered: the perpetrator and the victim. How do you treat with a perpetrator, 16 years old, 17 years old, who has had consensual sexual intercourse with another 17-year-old? How do you, life imprisonment? Because it's rape. It's rape.
For consensual.
Yes. Oh, for consensual. I see. Well, I anxiously await how it's going to be dealt with. I think.
120.
Oh, I thought my time had expired.
Mr. President, the time being 1:19, might the Senate be permitted to sit beyond 1:30 to complete the business of the day?
You've heard the questions. Those in favor? Those against? The ayes have it. Senator Knight.
I didn't want to take up. I didn't want to.
Clearly, vanity knows no age. Welcome back, Senator.
Thank you. It's the first time I'm coming out in the public with all this.
I assure you we will see your pencil.
Yes. There are some aspects of it that cause me some concern, and some that don't, but I'll just make a brief comment on them. I start with the comment made in relation to the Domestic Violence Act. And one of the things that was said was that domestic violence is not defined. But you don't need a definition for domestic violence, because if the situation, the relationship exists and something happens that is violent in nature, that something that happened already is classified. It's either something like rape, unlawful wounding, or assault, or something, so that the offense committed is dealt with in law already. So the relationship now will give rise to how it is treated. And so when the Domestic Violence Act, I happen to have been the person who piloted it and developed the policy. When it came into being, the contemplation then, and I am not saying it can't be changed, I'm just saying what the contemplation then was that when these acts are committed, rape, unlawful wounding, assault, etc., in the domestic environment, what remedy is available to the victim? And so the scheme of the Act was to set out the remedies that were being made available to the victim, and was not seeking at all to criminalize anything, because any criminal act committed in particular circumstances would amount to domestic violence. So maybe when we're looking at the amendment to the law, we can bear in mind that reality. What bothers me greatly throughout the entirety of the report is that there are too few instances where I saw where the legislators or those who assisted the legislators thought of, one, creating new institutions to deal with some of these problems. And apart from creating new institutions, there is going to be a tremendous need for capacity building. And in the circumstances, what I think should happen concurrently, because you are going to do what I'm suggesting on the basis of policy, is that there should be a team assembled to deal now with what are the institutions that will be needed to make this work. Because if you do not do that, then there is going to be disappointment at two levels. You don't have the institutional capacity, and you're going to be depending on the police. It won't work. It won't work. So I recommend that from day one, a team from the various ministries be assembled to deal with No, more broadly for the whole thing, because for everything in here, and you have to upgrade capacity. Let me tell you, for example, and it was mentioned, you mentioned substance abuse. I went to United Nations, and I was browsing in the library, and I saw this pile of documents, and I went, looked, and I saw that there was a thing called a drug court. It then existed in two jurisdictions, New Zealand and California. My permanent secretary was there, Mrs. Baker. I was so excited. I said, Mrs. Baker, look at the problem we are having in Jamaica with substance abuse. We have the National Council on Drug Abuse trying to deal with it, but we have the police dealing with it, and we have the society crying out about it and saying, you're locking up people for a spliff. And I'm going to tell you, and I'm speaking from a little experience, I'm going to tell you something else about substance abuse. You lock up a young fella for a spliff. He wants to go to university in the United States, and he can't. He can't. So, for example, now, that team I speak of should be looking at the Criminal Record Rehabilitation Act. Because, and I confess, no policemen in here, I confess that as Minister of National Security and Justice, I creatively interpreted the statute to cause the minister to have jurisdiction to expunge or the expungement. Because they would go to the board, and the board would oftentimes say, Senator Graham, boy, you can't expunge that. But the boy has an acceptance, and the girl, she has an acceptance from a university. She's a bright student, but she had a spliff once. Nobody challenged my interpretation. So, but I would prefer if in dealing with all of these, because what you don't want to do, you know, is you don't want to just incarcerate people, because when you incarcerate, there is no change in their behavioral pattern, save that it is escalated in the way of criminal activity.
One new university.
So you need now to look at how your complementary legislation can assist in the process. And as I mentioned, rehabilitation. For example, one of the things we put into the system was what was called COSPROD, Correctional Services Production Company, because that was for rehabilitation. Because what you want to do is to ensure in all of these things, because sexual offenders go to prison, you want to ensure that when they go to prison, they develop a kind of ethic that will cause them not to be recidivists. So now, as you develop this criminal legislation, you should at the same time be thinking of how do you rehabilitate these people. For whom? You are making arrangements to send to prison for a longer time. Great opportunity to learn, because they will be released one day. So the whole issue of capacity building and new institutions is important in dealing with this. It can't be just passing some laws, because it won't work. I thought through when Senator Morrison made his presentation. He said, look here, you know something? You need to begin to deal with persons with disabilities so they have access to justice. Because if they go into a police station and they can't be communicated with, they are denied access. That's a denial of access to justice. If they are denied access to justice, then what do? So far as they can, they're going to take justice in their own hands. So, you don't have to reinvent the wheel. Senator Morrison said university or the disabilities group, they have a training agency. We have at South Camp Road what is called the Justice Training Institute. The first principal of the Justice Training Institute was a retired resident magistrate named Mr. Noel Irving. And what did that do? There was training in sign language, training for disabilities to help them to have access to justice. And the training was across the board. from judge right to those who interacted with persons who entered the justice system on the first point. And that institute is there. And no high court judge was the principal too. And no high court judge was the principal. So it was not an institution, a training institution that was just brought into being. And, and what was it that was done? It was not a matter of just having it at South Camp Road. The staff, the trainers moved island-wide. I'm certain, for example, of training courses that were held in Mandeville, Mid-Island. So as we look at this, we either reintroduce old institutions, create new ones, and build capacity for them to do it. Otherwise, we are passing legislation and hoping for positive results instead of working and planning for positive results. That's what we got to do. Let's take, for example, the issue of rape. It's a very sensitive thing. A female of whatever age is traumatized when her body is violated. She's traumatized. And what can happen to her is that for years she can suffer from it. Her entire personality can change because she's affected in such a deep way. The violation leaves scars. But guess what? Many victims of rape don't report it. There is a kind of shame and guilt that they feel that cause discomfiture for them to go forward and report it. So an environment has to be created. And that is how what was then called the Sexual Offences Act unit came into being and developed into what is now SISOCA. Because there was a recognition that if you are going to be focusing on prevention of these rapes and so on, and detection of it, then you have to make special arrangements. And what happened in the Sexual Offences Unit was that what we did was we had to understand the psyche of the victim. And we have to understand the psyche of those who are dealing with the victims. And one of the complaints that was made was that when they got to a police station, they feel exposed. The policeman is dealing with them, and he's more sympathetic to the perpetrator than the victim. Sometimes the women too, but not as much. And what we did, the commissioner was the late Commissioner Ricketts. We sat and we said, what can be done? And Sexual Offences Unit came in. And then trained women so that they interfaced with women and set up a unit, we had about 3, where there was the psychologist, there was the nurse, there was, what you would call a medical practitioners. It was a nurse and psychologist and psychiatrist and so on. Health providers. And then what happened now was that there was necessarily an increase in the beginning of rape, but there was an increase in reports. There's an increase in reports. And if you have an increase in reports, and you build the capacity the other side also, then what happens is that it can eventually cause a decrease in the incidence of the violent assault on women. So when I make the recommendation of having these institutions ready, what exists? Increase capacity. What don't exist? Put in place. It has to have a holistic approach. Talk about domestic violence. Let me tell you. Domestic violence can arise out of family members or close friends lending each other money, Senator Brigham. And they lend them money and they don't pay back. Or you ask to keep the money and you don't hand it over when it's safe. Yes. And so what happens now? They resort to violence because they can't go to court. They can't go to a lawyer to go ask a lawyer to file a suit in a court for collect $2,000. Very, very, very few lawyers would go. Very, very few. So what happened? You resort to violence to settle that domestic dispute. So, round about the same time as dealing with domestic violence, we created what is called the small claims courts. That's how they came into being. Small claims courts. We moved court from the criminal court from Sutton Street, centralized it at half a tree and so on. Put in this civil court and the small claims court where people with $2,000 and $5,000 claims didn't need to go to a lawyer's chambers to employ one to be able to recover the money. They do it themselves with the help of the staff. So I want measures to be considered alongside the passage and upgrade of the various pieces of legislation. Otherwise, we are going to find ourselves disappointed with the brilliant effort that was put into the production of this. Understand that a lot of this in itself is calling on police action. Police action is to find this criminal, lock up this criminal, get this criminal convicted, put out the statistics of how many crimes solved, and move on. But the problem remains. So I am calling for action which can bring about societal change. It has to be a revolutionary approach. Can't be piecemeal. Can't be piecemeal. Let me tell you, what you're going to have to do too. What? And if I'm not, I'll be very brief. I'll be very brief. We have to look also at the building, and Senator Sinclair will no doubt understand that. This whole thing, Senator Sinclair, of the court dealing with these things, we may have to look at the Act, Poor Prisoners Act, is not that Legal Aid Act. Otherwise, you're going to have a clog in the system. Time up. 3 minutes. I really need 30, but I'll take 3.
Mr. President, the Speaker's time having expired, might it be extended to permit him to complete his presentation?
You've heard the question. Those in favor? Those against? The ayes have it. Senator Knight, please.
Thank you, colleagues. I'm not going to detain you at all, though I'll be with you as long as is possible. I have some notes here, Senator Graham. This approach, this review can be commended because what was clear was that the Joint Select Committee worked jointly, both from the angle of the Senate and the lower house, and from the angle of the government and the opposition. And I commend the team for having operated in that way. And I'm going to now suggest that in order to make it complete in perfection, that a joint team looks at what will be necessary to make it work, and a recommendation be brought or be taken to the appropriate bodies for implementation. Because what we want to do, and I hope I'm not speaking in a way that can be in any shape or form regarded as violent. But what we want to do is to put a stranglehold on criminal activity. That's what we want to do. What we want to do also is to bring about deep change in the society, attitudinal change. If we don't bring about attitudinal change, then we're going to be engaged year in, year out in rethinking how much penalty, what new offense, and so on. And I sit by reminding my colleagues on a number of occasions I have said from my seat there, there is not to be unemployed in this country one behavioral scientist. And those who have retired, call them back. If we don't do that by getting into the psyche of our youngsters and some middle-aged, if we don't get into the psyche, then we're not going to move forward. It's not just the economy that you restructure. You restructure minds so that minds become positive and productive. And the most positive thing you would like me to do now is to sit down, and I know do so.
Minister? I'm sorry. Thank you very much, Senator Knight. Minister?
Thank you, Mr. President, and thank you to all who contributed to the debate today. And I think the sobriety and the general consensus and the commitment to ensuring that there's a holistic treatment and improvement of how it is the state treats with this intractable issue of violence against vulnerable members of our society is indicative of the fact that this is legislation for this time. Perhaps we're at an appropriate point in our national development to make the changes that are in fact necessary for appropriate treatment of these issues. I just want to make one or two points, acknowledge one or two points. Perhaps I'll start with the last, just to assure Senator Knight and all who would have, of course, been listening to his point regarding training and capacity building. This must be a part of the process. If we are going to have implementation, there must be training, sensitization, and appropriate resources to ensure that these processes and programs can be implemented, and that the new legislation, as suggested by Senator Morris as well, that there is sufficient sensitization, not only at the judicial level, but at the community level, and community in the sense of not only the community of persons living with disabilities in respect of the PWD aspects of the legislation, but certainly the broader understanding of what we're trying to do as a society, to become more balanced, to become less aggressive, to become more caring, and to ensure that criminal enforcement is appropriately addressed for criminal behavior, violent behavior, and that matters which are social, that deal with maladaptive behaviors or or disorders, that they are treated with accordingly. And that will require human capacity building. One of the things that will be important is for us to ensure that our young people are learning as well, that there are good career paths in these areas as well. Everything does not have to be, lawyer and doctor and general practitioner, No, not Indian chief who was saying that, but just, to ensure that there are all of these areas, niche areas that require treatment and capacity building, rather, in respect of ensuring that we're able to bring new skills to the table as we seek to break the cycle of violence that Senator Longmore spoke about earlier. the importance of implementation, the importance of clear demonstration of political will, practical suggestions made such as the ensurance of use of audiovisual information at health clinics, at the antenatal clinics. I mean, it's key. We implemented the child health passport to capture data at the clinic, recognizing that 0 to 3 gap before you enter the school system, that the best place to access it is at the health clinic, and accordingly adding use of the time in an effective way. And there have been new programs developed in terms of connecting with babies and breastfeeding, and how it is that violence impacts children, and how abuse, what abuse is, and how parents need to think about how best to parent. So absolutely important proposals put forward as well. Training of the judiciary mentioned by more than one senator as well. And I believe there was a request to clarify the issue of the use of mental disorders versus intellectual disability in the predatory sexual assault clause. So we will look at that, not only in that clause, but ensuring that across the board, I think the ethos of the recommendations is that there must be greater protection, and there must be appropriate treatment and of the relevant offense in respect of the relevant disability. And that will be done across the board. And will, of course, add to the complexity just alluded to that may take a little more time. What comforts me somewhat is that there was considerable thought given to this during the deliberations. Meetings were quite long. They were, never sort of perfunctory 2-hour, 3-hour sessions. They were long in the evening. We had weekends. We had unusual sessions to ensure that there was the broadest discussion of the complexities, because we recognize, and that's partly why some of the drafting, I think, even of the report took some time. But yes, it will be important to ensure that this is dealt with. On the matter of domestic violence and the Domestic Violence Act, I completely understand the thinking that would have gone into the drafting of the act as it is then, because that really was the current thinking nationally and internationally about how domestic violence should be treated. Things have changed. Our understanding of it has developed, deepened, the impact on society and the nuances about how to interrupt the cycle, how to ensure appropriate interventions. Those have changed, and the scope of what is considered violence from a social perspective and a psychosocial perspective has changed as well. So that domestic violence now generally includes the psychological as well. For example, it is not only the physical manifestation of violence that would fit under assault, which is now considered. And there have been creative solutions in terms of how police deal with as well. In Guyana, it is an offense for a policeman not to take a domestic violence report. And so that's one type of enforcement. The committee didn't recommend that in particular for our use here, but there is a thinking about recognizing the very issue that Senator Sinclair raised, which is that if someone is not going to press charges, but you recognize that a crime has been committed, what is the role of the state, where this now, which has traditionally been treated as a private matter, is now one which is affecting the children who can't learn in school. It's affecting the woman's productivity on the job. She can't learn, she's unhealthy. This is, she can't go to work. And the general cycle of violence and how it creates perpetrators and of victims, creating a continuously violent society. So how we interrupt that cycle and how we treat with the definition of domestic violence has to fundamentally be revisited. So the scope of the act is being fundamentally revisited. How the protection orders and occupation orders are dealt with. In fact, you would have recognized that even the issue of the occupation order was recognized as too complex for the committee to deal with. So the committee was, the recommendation actually tasked the technical teams to look back and look more broadly at how it is that you would deal with an occupation order, especially in circumstances where there was previous evidence of domestic violence, and how that's treated from an evidentiary perspective, which wouldn't allow you to take it into consideration. So the complexities were acknowledged, but that's one of the reasons why you don't actually see many specific recommendations for the DVA, because it has to be redone from bottom up. So, but it was appropriate for its time, and it continues to be all that we have in that regard. But we hope to be able to change it fairly quickly, all things being considered. But that being said, Mr. President, again, I really wish to commend everyone who was a part of developing the report, supporting us legislators in the process of the debates that took place in making the recommendations. And I want to just encourage all who will now be a part of improving the legislation, creating the bills that will come right back to us here, so that we can ensure that the most appropriate decisions are taken on the amendments, so that we do in fact improve the legislative framework as a cornerstone of a less violent Jamaica, as we all need and want. So, Mr. President, with that, I ask for the Senate's approval of the report of the Joint Select Committee tabled previously. Thank you.
Thank you, Madam Minister. Before asking for approval of the Senate, I just add my own recognition to all the persons who participated in the presentation of various papers, etc., that led to the creation of this paper, all the members of the Senate and indeed the members of the committee, and as pointed out earlier, members of staff of the Parliament and the members of the staff of the Ministry of Justice. So, members, you have heard the debate today and the question put by the Minister. All in favor? Aye. Against?
Mr. President, we'll now proceed with the Regulations Committee reports. Thank you.
Is Senator Braham ready? Is Senator Braham ready?
With some trepidation. Mr. President, I now move for the suspension of the standing orders to enable me to take the motion, notice of which I gave earlier.
Motions, but you're going to do them one at a time.
I was hoping to do them all together, Mr. President.
Do them one at a time so we can move through it. No, we have agreement. Okay, thank you. You can go ahead with the motions. Those in favor?
Aye.
Go ahead now.
Yes. Right. There are five resolutions, 4 of which deals with the National Housing Trust, and the 5th had to do with an insurance issue to be referred to the Regulations Committee. And so I believe that they are without controversy, and if I am correct, I would ask that, Mr. President, that they be approved. Did I get that right? Yes.
Thank you very much. As you said, 4 motions relative to the Housing Trust,
yes,
and 1 in relation to deposit insurance. And the members have heard the question. Those in favor? Aye. Against? Minister? Well done, Senator. I'm only sorry your nephew wasn't here to see you.
I must say, Mr. President, that this spirit today is indeed a positive one. I'm not sure what change has occurred today, but long may it continue, Mr. President. It is not intended to do any further work today, Mr. President, any further business. Might the Senate be adjourned for a date to be fixed?
Thank you very much, Minister. The question is that the Senate be adjourned for a date to be fixed. Those in favor? Against? This honorable sitting of the Senate for the 10th of July, 2020 is hereby adjourned.